Thank you very much. Cody and Score, thank you for having us. We've done a presentation in the past, and it was about inventing and commercializing your invention. And there was a really strong topic of protecting your intellectual property that came up. So this time, we wanted to get really into the activity of when you do come up with an invention idea, when you have your business idea, and you're looking to get it protected in patents, trademarks, copyrights. There's all different types of assets to build up assets for yourself and build up value for your business or your invention and to commercialize it eventually. Throughout the presentation, I'll be going through and giving my perspective as an inventor. And just a little bit about me. I'm an inventor. I have 15 patents. I have over 100 trademarks. One of my latest inventions is the paper towel topper. I license products and earn royalties from them. I manufacture products, whether it's overseas or local. And I've been doing the same thing, coaching and consulting other inventors for over 18 years now. Some of them turn into brands, some of them license, some of them have one product that they end up commercializing. So I've really had the experience of kind of project managing many people's invention ideas. They start off as ideas in their head. I've also been an on-air guest on QVC for about 3 years. I've authored 3 books. My latest book, which I'm really proud of, is How to Make Money with Your Invention Idea. I created an online e-learning course called Inventor Class, How to Make Money with Your Invention. And I also host a TV show called Got Invention Show, where I promote inventors with their inventions. And I've been very active with inventors clubs. I founded inventors clubs 16 plus years ago, and now recognized as the National Inventor Club, and interview high-profile guests there, try to get as great information out there as possible to the inventor and business entrepreneur community. And now I'm a creator. I'm really proud. I just came out with Inventor Smart Community. It's an app that you can download on Google and Apple. And there's our own social media. There's tools and resources on there to keep your ideas moving forward. So I'm really excited about that. And we're ready to get started learning about patents, trademarks, and copyrights. Okay, so Janet, do we want to start on the next one?
Yes, and that's over to me. So what we are going to start out with is that overview of the 4 different kinds of intellectual property. For each type, patent, trademark, copyright, and trade secret, we want to provide kind of the who, what, where, when, why, and how for these 4 forms of intellectual property. This will be the foundation for you all to understand the different types of intellectual property that you may want to protect. Now at this point, let's talk to Brian. He has a considerable amount of experience with all forms of these 4 intellectual properties. So I think it would be really great to gain some of his insights on how he decides what kind of intellectual property protection when he has a new idea to pursue. So what are your thoughts, Brian? How do you make that decision?
Thank you. I could say that the IP evaluator tool that you showed before is really, really great. I think it's very easy to use, and it gives great advice and kind of give you that guidance on where and what to do. I've been doing this for a little while now, and I could say that building your IP protection and building with patents and trademarks and copyrights, I think it's really important to build up. And like I said earlier, it's to build value. It's to kind of put a package together and figure out what you want to do with your intellectual property. Do you want to license your invention to earn royalties? Do you want to manufacture it and start your own business? And these are the things that I have to think about when I'm coming up with an idea to kind of guide me in what I should do and how much I should protect. And even copyrights that Marissa mentioned earlier, and actually Janet mentioned earlier with copyrights. You can even use copyrights for technical drawings of your invention. So there's a lot of different ways that I've gotten a chance to learn about intellectual property. But, sometimes either a patent attorney or agent, I'll go through what those are in a little while, but I still seek the advice of legal, whether it's somebody who can understand the intellectual property and can communicate with the U.S. Patent and Trademark Office, or an intellectual property attorney, an IP attorney. But yeah, you can try to squeeze as much intellectual property protection as you can for your idea and your business.
Brian, what advantages, you mentioned that it's maybe good to seek legal counsel. What advantages do you think that legal counsel provide versus trying to seek protection on your own?
Well, we all look, as inventors, entrepreneurs, and startups, we probably feel like we can do it all. And we probably could. And if we put our minds to it, we'd be able to figure it out. But I don't know if anybody's ever looked at a patent with the claims and the way that it's formatted and what's required within. I usually, and pretty much all the time, go with a patent attorney or an agent. And I mentioned that before. So a patent attorney went to law school and they can litigate, so they can represent you in the court of law. If you use a patent agent, they are registered with the U.S. Patent and Trademark Office, and they can kind of represent you on your behalf to the U.S. Patent and Trademark Office. So they could do filings, they could do office actions, but if you need to go to court, then you use a patent attorney. So for me, I usually use a patent agent when it's something heavy and I might need to get a little bit more into detail. I might use a patent attorney, but they're both available for advice and legal advice, of course.
And then, Brian, another question in your introduction, you mentioned that you've licensed a lot of forms of intellectual property. You've collected royalties. Do prospective licensors sort of have a checklist, like they want to see a patent, check, they want to see a trademark, check, or does the value of your invention increase based upon the multitude of intellectual property forms you have for it? How does that all work?
Sure. Well, licensing, just to start off with, because people might hear that word thrown around a couple times throughout the presentation. Licensing means that you came up with this idea and you're going to go to a company that is kind of in the same space, in the same category, and you're going to ask them if they'd be interested in manufacturing your invention and also distributing your invention. And they would make it, they would sell it, and you would earn a royalty from it. So that's typically how it works. There's obviously variations of that, but and to get into details of what a licensing agreement looks like. But for the most part, when I speak to a potential licensee, we would be the licensor as the person or the company that came up with the intellectual property. It is kind of important. If you don't have any intellectual property, if you don't have even a patent pending status, then if you don't have any intellectual property and you're showing it to them, you could show it under non-disclosure agreement. And I'm just talking from my opinion and my experience. Realistically, they might not need you. They could just do it themselves. So if I have a chance to get intellectual property protection, a patent, copyright, trademark, then I try. I build up assets to be able to give that licensee, that manufacturer with distribution, a competitive advantage in the market. That's what this is about.
Would having a patent or a trademark potentially increase the amount of royalty that you can earn?
The royalties are most of the time based on the margins. And look, it's also what type of company you're attempting to license to. If they have mass distribution, their margins are going to be really tight. So the better assets that you give them, the better of the advantage it is. But when it comes down to what your royalty payments are, it's most of the time based on the manufacturing. And look, when you license, you're a partner. You want to be able to find a good partner. You want to help them so they can sell more. So look, there's no straight answer to it. Every opportunity and every licensing agreement is different. But the more advantage you have, like let's say you're selling in the market and it's doing well, you probably have more of a leverage to maybe negotiate a royalty deal. But again, there's no textbook answer to this. It could be based on the opportunity and the licensee.
Thank you, Brian.
Thank you.
It was
And
real.
and Janet, there was one more question on the timing, and I think this is kind of important just to touch on because I'm not. Sometimes you come up with this idea, and I mentioned this in my previous session that I had with SCORE. You get this feeling, like you get this emotional excitement, this butterfly in your stomach, like you're so excited about your idea that you want to just figure out what the next steps are immediately, and you might end up in different places. So really, when you're talking about the timing of filing intellectual property, you just got to take a step back. First thing to do is jot your idea down. You don't want to lose it. Capture that idea. There's many ways. You could text yourself, leave yourself a voice message, whatever it is, capture the idea, and just kind of go through, and we'll go through kind of like doing a search, and we'll go through this in a little while, but do your search and then come up with something that might describe your invention, or maybe it's a prototype that you might make. So get it to a point where you feel like you kind of got it where you need to be. And it doesn't have to be perfect if you're licensing most of the time. Maybe you have CAD files that you do, or maybe you're making a crude prototype, and that's okay. They may pick up where you leave off. But if you're manufacturing, you probably want to get it really to a good point in your before you go into production. So I like to get it as close as possible to what it could be before I file. You can easily file a provisional patent application, which you'll go through. I don't want to take your information away, Janet, but a provisional patent application will give you the right to say that you're patent pending for a year before you file your non-provisional patent application. And the same thing with Marisa and trademarks is you can also file an intent to use. So there's different ways of timing your intellectual property, but we'll leave that towards the a little later in the presentation. Sound good?
That sounds great. Give everybody a little teaser.
I want to hear from you about some of your experiences as an inventor. So first of all,
sure.
Go ahead.
You know what I found really interesting, Marisa, is how you can put a TM. So you could put a trademark on pretty much what you're putting out there in the market. And when you show the trademark office that you're using it in commerce, the little TM turns into the R. I love that.
Yeah, it's like magic, okay? You file your application with us. You might be coming in based on common law rights, even if maybe you've been using your mark for years and years. But when you file your application, you can still file based on use. You can say, provide your date. And then when you get that registration certificate, all of a sudden, you now have permission to use that R in the circle.
So when I started getting involved with trademarks, I built a brand of backpacks, stationery, T-shirts, mugs, different types of accessories, and it was teen tween related. And it was fun until I started to realize that I was in many classes of goods that I had to cover. And if you're doing it, like you mentioned, if you're putting it out there where you're intending to use it, you pay a little bit more. And then when you do use it in commerce, then you go back to the trademark area, you show the specimen that you're using it in commerce, and then it converts into the registration mark. So I started to save a little bit when I started to use my trademarks in public, selling them, and then I saved, I think, $100 per class of goods. So that was kind of helpful to me. But yeah, it's trademarks can be a really great benefit. I start off also because I want to know that I can maybe protect myself, and not so much as legal or intellectual property protection from the USPTO, but even to come up with a good domain name, to come up with a good name for your invention, for your business, and then be able to also go in to the trademark office and where you showed that TEAS, you can go in and search for the different names that you may be thinking about for your invention or for your business. And then you could see they pretty much come up. That's doing a trademark search. If it's live or dead, I don't really like that word, but live or dead. And you can see that if somebody or a company is actually still using it in commerce, and you can kind of either get some legal advice to see what direction it can go, or it's pretty clear that it's open. But it's interesting because that class of goods, you can really hone in on what your class is to be able to see if there's somebody else, a company that's already using it in commerce, right? I wanted to just tell you also that my experience with trademarks, because a lot of people think about logos, trademarking their logo. For me, I like to use word marks. So there's logos which you have to get kind of descriptive of how your logo looks, or you could do a word mark. To me, that's more powerful because I could take my word mark and I can wrap it around any type of logo that I want to be flexible rather than just specifically on logos. Can you just give us a little bit of advice? Because that comes up a lot when I'm talking to inventors, especially.
Sure, sure. So I'm not giving advice, but I am going to give you the rule. And here's the rule. So when you think about filing your trademark application with us, you're going to be asked for a drawing. And in that drawing, you can say you want a standard character mark. And a standard character mark gives the owner the most flexibility, because if it's in just all letters, standard letters, then you can use it in any color and in any font, which gives you a lot of protection. If you want a specific design, though, and you upload a JPEG, well, whatever way that mark is shown is how it's got to be used in the marketplace. If it's in color, it has to be used in a specific color. But if it's in a black and white drawing, a black and white JPEG, you get to use it in any color you like.
Thank you. And doing or filing a trademark, it's not that complicated. I mean, obviously, anything when you're doing it over and over again becomes easier. It's to be able to search the trademarks, to take a look at the class of goods, to see if there's a domain name, to see if there's live or dead activity within that trademark. Those aren't too difficult to kind of do. Sometimes I do seek a patent attorney to be able to help me with figuring out if it might be too similar or sound the same, like Marissa was talking about. You have to think about the sound, the class of goods, the way that it might be shown if it is a logo. So, look, again, this is another kind of asset that you can put in your presentation if you're going to build some value for your company. So trademarks are very important in my opinion. And we are going to get more into the patents, which is a hot topic.
So now, Brian, I'd like to talk to you more about your experiences with the patent system. Does that sound good?
Sounds great. And that Inventor Assistance Center, you don't necessarily have to be an inventor, because there's businesses that utilize intellectual property of patents and copyrights and trademarks. Copyrights aren't necessarily in the U.S. Patent and Trademark Office. Copyrights, which I answered a couple questions, you could go to copyright.gov is the website for the copyrights, or copyright.gov. But yes, Janet, let's talk patents.
Okay, fantastic. I'm always interested in hearing views from those who've used the system and really know how to navigate it well. So my first question is about those different kinds of patents I talked about, the utility, the design, and the plant patent. So I'd like to talk about just what in the marketplace do investors, do licensors, what do they want to see as far as patent protection? Is it better to go the utility patent route, the design patent route, or maximize it and try to get both types of patent protection?
Well, I could say, Janet, that when I talk to inventors especially, or people with ideas, they don't even call themselves an inventor yet, but they are. A lot of times they want to just kind of skip some of the steps. And I think it's really important before you pitch somebody, you have to be real and say, is this something that I can call my own? Because yes, you can file and go through the process of being brought in front of an examiner with your intellectual property, with your idea. But so many times, Janet, people end up starting on step 5 when they need to do a search. And you could do a search with a patent agent, a patent attorney. You could start off by doing it by yourself. You know, Janet, a lot of times, and I say this, people say, oh my gosh, I just came up with this great idea. I haven't seen it out there. Everybody in the world is going to want it. I went to Walmart and I didn't see it on the shelves. So I know that I can keep moving forward. It's a good start. Picture and visualize where you see your invention going to be. That's a good start. And take a look and see what's out there. But then go back home or go to your office and put in descriptive words, even in the Google search or in the search engines. Put in descriptive terms and see what comes up in other on other websites. And then instead of going through website by website and links, I just click on images and I could take a look at the visuals of what comes up to see if what I came up with is unique enough to really be able to call my own. So I start to capture them. I go to the different stores that I visualize my idea. I capture those. I capture URLs of things that I see that are similar. So why is mine so different? So I put that together and then I go to a patent attorney or agent and I say, here's my idea. Here's things that I found. I can even go on uspto.gov and do a search there and find some patents that I can maybe compare to, have them compare and see, is my idea patentable? It's only their opinion, but is it enough to be able to call my own? Do you see something that I can do differently from what I'm proposing to be able to capture that to be my invention? So I think a lot of people are really excited and we want to keep going forward. And then when we end up going to somebody, like people call me up as a licensing agent and they say, Brian, I want you to help me to license this. And in 2 seconds, I find the invention online. Why? Because you want to search with your eyes closed. You don't want to find it. You don't want to, like, you're coming up with this idea. Maybe it's going to be something that's good residual income for you. Maybe it's something that you want to be your full-time job. You want it to change your life. But reality is that it might not be your own. So a lot of people just skip it. And when you're going to pitch an investor, a potential licensee, a licensing agent, whatever, and in 2 seconds you find it, that kind of hurts. So I think it's really important to try to get through that step of the patent search. And then when you're talking about pitching, yeah, if you feel like you're kind of in the clear, maybe you want to get a second opinion. If you hit a brick wall, I'm okay with that. Look, you just came up with an idea. You're probably going to come up with another one because you're in that zone. But realistically, this one might not be the one, and that's okay. Work on something and put your time, money, energy, effort into it to be able to work on something that maybe can make you some kind of return, right? So I start off with possibly doing a provisional patent application, and that's going to give me that 1 year to say I'm patent pending before I file the non-provisional patent application before the year expires. And I can kind of market and pitch. I could go to a trade show and say, I did my due diligence. I did a patent search. I have a prototype made. I'm at a good point where I can show it and be protected with a provisional patent application. And then I'll file before that year a non-provisional patent application. Maybe I want it to be more ornamental. Maybe I hit a brick wall with the utility side of it, but maybe it looks different and I can use the ornamental part of it, which is a design patent. It's 15 years instead of 20 years, but it's going to give me some protection. And if I'm going to pitch it, a utility most of the time is a bit stronger than a design, because design, you can change it enough to maybe change it where somebody else can call it their own. But yeah, maybe I'll do a mix of utility patent and a design patent. I might throw in the copyright, like I mentioned earlier, to have kind of the technical drawing side of it. I'll come up with a good name and I'll trademark it in that certain class of goods. So I think intellectual property and with patents being together make you a strong candidate if you are looking to license or raise money for your invention.
You've given some really great suggestions about how to get started, especially in those early boxes in the patent process. Let me ask you about talking to the examiner in an interview. Let's say you get a rejection the first time around. Have you utilized the Inventor technique or tool to help overcome those rejections, like iron out your differences with the examiner? And what are your thoughts on conducting an interview?
Well, the first time that I filed a patent and I ended up getting the rejections, it hurt. And then when I found out that it's pretty much all the time that it happens, the examiners need clarity on, and you're a vice chief judge, so hopefully, that's what it's like. You have to clear up what it is that they're challenging, the examiner. And I've done it with patents and with trademarks. And the trademarks could be a little bit easier. The patents, the language and the claims and the way that it needs to be formatted might be a little heavy for somebody. Even for me, after 15 patents, I still use a patent attorney or agent to communicate. But if it seems like it's something reasonable, every time I've called a patent examiner or a trademark examiner, it's been easy. They're receptive, responsive. I can talk to them on the phone. I can email them, whatever their preference is, or if they're open to it. And they can kind of talk you or walk you through what the challenges are. You could step back and think about it and maybe answer it, or get somebody to help you, like a patent attorney or agent, to respond to it. And you might end up with certain claims that go through and others that get rejected. And maybe you're left with a couple that make it enough that you can have a patent. And the claims really are your meets and bounds, like the territory and the property lines of what you came up with. So the more you have, the stronger it is. And with a design patent, it's ornamental. Like I said earlier, in the trademarks you have in a certain class of goods. So yes, I think they've been friendly so far, just like you, Janet. And they're there to help you. But if you need some legal advice, you could do it. If you call up the Inventor Assistance Center, they can guide you on the route to go. And even with your PTAB area, Janet, which is the Patent Trial and Appeal Board, if you get a rejection and then you get a second rejection, there are options available for the inventor, for corporations to kind of go through and challenge the examiner. So you still have some options if you do get rejected.
So you get that first rejection and you said, you're really heartbroken. What happens at the end of the process when you're simply not able to convince the examiner? They give you a second rejection. So you're sitting there evaluating, where am I going to spend my resources? What do you typically do?
Sometimes I agree, and it seems like they're right. I mean, they're going into the archives. They're looking at things that have already been patented. So there's a couple questions that came up also, Janet. After 20 years, the patent is in the public domain. So anybody can really make the same thing, but you're not going to be able to get a patent on it again. Maybe if you change the design, it's ornamental, and you might be able to get a design patent. But there's a point where you might be hitting a brick wall. And if you're not, and you feel strongly about it, and you get some legal advice, in my opinion, that says, you know what, I think you have a shot here. That's only my opinion. Maybe you want to get a second opinion, and then you can challenge it. And there are options available for that. I also wanted to mention, I know that we might talk about it earlier, but since we're talking about filing, for those who qualify, I've been active with the pro bono program with the U.S. Patent and Trademark Office, and that's free legal filings. that some of you may be eligible for, and you should look into it on the uspto.gov website. So yeah, I mean, look, there's options available. There's ways to be able to help us to get through it, but also be realistic. Just like when you when you came up with the idea and you didn't search online to find it, and then I found it in 2 seconds. I know it's painful, but it's okay. It's better than going further down the line and spending all that time, money, energy, and effort and just kind of hitting the brakes there and moving on to your next idea.
Well, Brian, shall we? We have lots of audience questions. Shall we move on
do.
now? Maybe talk a little bit about what other resources are available for business owners and then
Absolutely.
take those questions?
Let's do it real quick. So I think everybody on here watching and listening should go to uspto.gov. Whatever you need, just put it in the search. It's really user-friendly. It comes up. The Inventor Assistance Center has been a lifeline for me, kind of going through and navigating through the process. But I also have Janet's email address. So no, I'm only kidding. I'm only kidding. I keep everything separate. No, but Inventor Assistance Center, if I need forms, if I have questions, it's really helpful. And then I think the second one, or one of the other ones you mentioned, there's patent and trademark resource centers, PTRC, they're called, and they're really helpful. I'm in Long Island, New York, and I have one here in Smithtown, New York. And Will Salas does an amazing job and he represents the U.S. Patent and Trademark Office in the library, Smithtown Library. There's PTRC centers in your area. They'll help you to search. When you come up with an idea, you can kind of capture what you're coming up with, and they'll help you to pull out prior art, look at the claims. They're not going to give you legal advice. They're not going to tell you how great your invention is, or if it's not going to be a great invention. They don't do any of that. They'll help you to go through the search of what you're coming up with to pull out and compare. I think that those are a couple good ones.
Well, let's you want to take some audience questions now?
Let's do it. Let's do it. I think we have hundreds of questions.
So the first one here is somebody is asking about international protection. They have a patent that was issued in 2014. However, they're trying to see if they can extend that protection to international protection. And then they have a second follow-up question after we answer this one.
From an inventor perspective, look, there's only so much that I can protect. If I do file in other countries, then I'm responsible for enforcing in other countries. So if somebody takes my invention and they make it in another country and they sell it there, I'm kind of out. But if they try to bring it into the US, that's where I'm protected. So you have to make a decision based on your strategy of your business. There's a lot of big corporations that file all over the world because that's their distribution channels. So think about that before you file. It could end up getting costly, not only for filings, but for protection. So depending on where you are and your strategy is what you should consider. What's next, Cody?
We have another question here, and this is asked quite a lot. Could somebody address AI in respect to copyright? There are a lot of people in the chat who use AI-generated art for logos, for images of all sorts, and they're wondering, are you able to copyright AI-generated art?
And I guess I can't get in trouble, so I could say, no, I'm only kidding. I mean, if you came up with something that kind of said the way that you want your logo to look, and you put a name on it, and that's your name, and it's representing something that you're selling, then it's possible to get trademark, maybe a copyright, if it's designed. But again, I'm going to leave this for the legal team. I enjoy AI. You want to be able to utilize it to the best of your ability, and it definitely helps and supports what you're doing. So trying to make our lives easier. But yeah, as far as being original art, I would consult with a patent attorney or agent or an IP attorney, I should say. Janet, we also had the last slide had our contact information on it.
So I want to thank everyone for attending today's webinar, and I want to end by giving our attendees a few options in order to get their questions answered. So of course, what we have on screen now is our speaker's contact information. So if you have any questions about this presentation, you can contact them using the contact on that slide. So I'm going to move off this slide real quick. You will be getting this slide in a post-event email, so you'll be able to view it at a later time. So, and then lastly, here at SCORE, we do offer free mentoring services for small business owners. So if you have questions about patents, about building a business around your product or anything like that, we have mentors, hundreds and thousands across the United States, and you can search for the specific mentor you're looking for by zip code, by their name, by their expertise at score.org using the link on the slide. And so with that, I'd like to give thanks to our presenters for presenting today's webinar. Thank you so much for your time and for sharing this valuable information with the SCORE audience today.
Thank you very much. It was great. And thank you for U.S. Patent and Trademark Office, Janet and Marisa, for helping me through just getting all the answers and information out to the inventors and the entrepreneurs and startups out there. And Cody, thank you so much. SCORE is a tremendous asset. People should take advantage of it. SBA with Small Business Administration, SBDC, really everybody should take advantage of the resources available. So thank you again, Cody.
Well, thank you both for volunteering your time. And with that, we'll go ahead and close out today's webinar. Take good care, and we look forward to seeing everybody next time. Bye, everyone.
Thank you.